The danger in all ADR is that total costs, being the cost of the parties, the lawyers and the ADR practitioners, begin to get close to what your clients would have to pay if they went to court for litigation. Often arbitrators start to act like judges, and they have a sense they should be charging as much as, if not more than, the lawyers who are sitting around the table. And in doing so, it starts to distort the value of the arbitral process and may disqualify people from engaging in the process. And I think it would be very harmful for the profession of arbitration to have to accept criticism that it's no longer cost effective, or that some disputes are simply too small to be arbitrated. And that's especially so when many contracts and agreements, obviously as you know, include a mandatory arbitration clause. To offset the often high costs of arbitration, a number of practitioners in mediation and conciliation have begun to market themselves as low cost. However, those of us in the business of practicing ADR professionally term their approach as fast, loose and dirty. While on the surface their service appears to be time and cost efficient, this approach is concerned only with the final outcome. It's outcome focused, and it therefore neglects the need to air and resolve the genesis and the crux of the dispute. It's really a misappropriation of the process, and it can be devastating for the involved parties in the long run. The question is then, what can be done to ensure that ADR remains a cost-effective alternative to litigation? And I don't believe that undercharging is the way to go, because you're still employing an ADR practitioner to bring their skills and experience to the dispute. But what I think is really important is that parties have to know that they're getting value beyond the implicit confidentiality from the ADR process. And there are two ways in which value can be generated: pre-preparation and tailoring. Pre-preparation involves the practice of mediation and conciliation away from the traditional notion of sitting down for a day to bash out an agreement. And while the practitioner may be able to rest easy that night, the involved parties are left dissatisfied with a settlement but an unresolved dispute. They didn't get a chance to air their grievances. They may have made concessions too early or unwittingly. And more often than not, as lawyers, you find that as soon as your clients make a concession, the ADR practitioner will start and begin the process of horse trading. Let's do a deal. It's the obligation of the ADR practitioner to keep unpeeling the layers of the dispute, even if a concession is made, because if it was made unwittingly in what is a highly charged emotional situation, then your client is never going to feel happy or satisfied with the outcome. Pre-preparation combats these issues by employing meetings and conferences between the ADR practitioner and relevant parties as a means to isolate issues and engage the parties in resolution before the substantive process commences on the day. What I found in the old style one-day mediation or conciliation, it's the most confronting and polarising position people have ever taken and are placed in. They've been at it for a long time and they're not ready to let go quickly. For a dispute to have risen, there's going to have been some kind of collapse in trust and confidence. And you can't resolve that core loss by fast, loose and dirty. Pre-preparation must be undertaken to engage the parties in resolution. In ADR, there are a number of practitioners, often a bewildering number of practitioners, in what can only be described as a crowded room. A crowded room in which the practice of ADR has become formulaic, with most legal professionals around New Zealand able to recite the script of many of the ADR practitioners and the commonisms that they use. The BVA approach to ADR is to tailor. There is not a script, there's no set structure. It's about tailoring the process and the language to the needs of the clients. Across the three broad types of ADR process, arbitration, mediation and conciliation, there is room for individual tailoring to meet the needs of the clients and other involved parties. Whether it be the time frame, the setting of costs, the contact with the involved party, how the day proceeds, whether it proceeds on one day or more, ADR can be tailored to meet the exact needs of your clients. And the sooner the tailoring starts, the better and quicker the resolution of the dispute will be. Tailoring, efficiency and efficacy is essential in the handling of the dispute. Just so is the right language. And to put it simply, a dispute is massive. People underestimate the distraction in their personal, emotional, financial and business lives that a dispute carries.